Hello, I'm attorney Kiara Swinton. If you've been charged with a DWI in Virginia, one of the biggest sources of anxiety isn't always the charge itself, but not knowing what happens when you go to court. People often ask, will I have to speak? Will the officer be there? How will the judge make a decision about the case? In this video, I'm going to walk you through step by step what typically happens at a DWI court hearing in Virginia so you know what to expect. Oftentimes, if you have an attorney, you and your attorney will have an opportunity to review the evidence in your case before your trial date. This evidence typically includes police reports, the results of a blood or breath test, and any dash or body camera footage from the officers that are involved with your case. After having an opportunity to review this evidence for its strengths or weaknesses, your attorney can initiate negotiations with the prosecutor about a potential resolution or reduction of the charge if that's in your best interest. However, if the evidence weighs in your favor, your attorney can use this evidence to build what's called a motion to suppress or another evidentiary motion in hopes of having your charge significantly reduced or dismissed. On your court date, your case will usually be called in the General District Court. When you arrive, there will typically be multiple cases scheduled for the same time, and a judge will call each case one by one. Before your case is called, there may be another opportunity for your attorney to speak with the prosecutor in your case to hammer out any details about potential resolutions. This may also be the first opportunity your attorney has to speak with the prosecutor, depending on when your attorney was hired and when a prosecutor was assigned to your case. This can vary per court. In some instances, your case may be continued to a later date, or it may proceed to entry of a plea agreement or trial on that same date. When your case is called, you and your attorney, if you have one, will step forward. A judge will typically ask if you're pleading guilty, not guilty, or no contest. No contest essentially means, I'm not saying that I'm guilty, but I agree that based on the evidence against me, a judge would find me guilty. If you have an attorney, your attorney will typically handle speaking on your behalf and confirm any terms of a plea agreement if one has been reached. If you're pleading not guilty, the judge will typically put your case back down to be called towards the end of the docket because trials take longer than things such as continuances or plea agreements. In Virginia, DWIs are generally bench trials, meaning that a judge and not a jury will decide the case. At trial, the Commonwealth, typically represented by the Assistant Commonwealth's Attorney, otherwise known as a prosecutor, gets to present its case first. This typically begins with calling the officer who made the traffic stop. This officer may be asked questions about any observations the officer made about the person's driving behavior, any observations of the driver, any statements made by the driver, and how the driver performed on any field sobriety test. The prosecutor may also present evidence such as dash camera from the scene, body camera footage, and the results of any blood or breath tests that were administered. For example, after playing a portion of the dash camera footage from the scene, a prosecutor may ask an officer to testify to things such as an allegation that the driver weaved in and out of multiple lanes, the driver had trouble balancing during field sobriety tests, and that there was an odor of alcohol. These things form the foundation of the Commonwealth's case. After the officer testifies, your attorney will have an opportunity to ask questions. This is called cross-examination. The purpose isn't to argue, but rather to highlight inconsistencies or errors in what's been presented. Your attorney may ask questions about things such as road conditions, whether or not the field sobriety test instructions were correctly given, and whether or not there are alternate explanations for the behavior that the officer is attributing to impairment. This is critical to building your defense strategy in your case. After the prosecution finishes, the defense will have an opportunity to put on evidence. This may include putting on witnesses to contradict the evidence presented by the prosecution, such as a scientific expert to testify about the results of a blood or breath test. In some cases, a defense will choose not to put on any witnesses, but instead to rely on the argument that the prosecution has failed to meet its burden of proving a DWI beyond a reasonable doubt. This is the highest standard in our legal system. It means that a judge must be firmly convinced of each element of the charge before finding a person guilty. Otherwise, the case must be dismissed. After all of the evidence is presented, both sides have an opportunity to make arguments. The prosecutor will argue why the evidence meets the legal standard, and the defense will argue why it didn't. The judge then has an opportunity to apply the law to the facts of your case to make a decision. In many cases, a judge will make a decision that same day. The judge may find you not guilty, find you guilty, or in limited circumstances reduce or amend the charge where appropriate. If a judge does find you guilty, sentencing will typically proceed on that same day, or in some cases be set out for a later date. A judge may consider facts such as your prior record, if any mitigating steps you've taken before trial such as community service or a substance abuse evaluation, the alleged blood alcohol concentration, and any allegations about the circumstance of the stop. Penalties for a DWI in Virginia include a mandatory fine. It can include a jail sentence, suspension of your privilege to drive in Virginia, and mandatory enrollment in our Alcohol Safety Action Program. Many people are surprised at how structured and evidence-driven these hearings are. It is not just a conversation, but a formal process where both sides present evidence and a judge applies the law. Small details such as how a test was administered or how a question was answered can carry significant weight. A DWI hearing can feel unfamiliar, but understanding the process can help you approach it with more clarity and fewer surprises. If you or a loved one are dealing with a DWI charge, you can contact my office at 571-322-6289 for your free consultation.